The hallowed walls of the Supreme Court chamber stood silent, save for the soft shuffle of papers and the hushed whispers of those gathered in anticipation. It was a scene that had played out many times before. Another day in America's highest court, another critical case with profound implications for the future of the nation. But on this particular day, the air was thick with a tension that no one could have predicted. Justice Amy Coney Barrett, seated with poise at her place on the bench, leaned forward, her eyes narrowing as they fixed on the woman standing before the court. Pam Bondi, the former Florida Attorney General, was representing a coalition of 17 states in a landmark case that would decide whether the federal government had overstepped its constitutional bounds in regulating state powers. Barrett's sharp intellect and reputation for no-nonsense legal analysis were well known, and it was clear that she had set her sights on Bondi. Barrett, who had earned respect for her unwavering commitment to originalism, had been anticipating this moment. She had prepared for months, knowing the stakes of the case, and had no intention of letting Bondi slip through without scrutiny. The case, Federation of States versus Department of Commerce, involved an issue of immense constitutional significance: whether the federal government's overreach in areas such as taxation and land use infringed on the rights of individual states. Bondi, a woman who had spent years prosecuting high-profile cases as Florida's first female attorney general, had entered this battle with a mix of practical experience and a profound understanding of the law. Yet her critics, who had questioned her qualifications for such a high-profile case, seemed determined to challenge her every step of the way. The tension in the room was palpable as Barrett began her questioning. "Miss Bondi," she began, her voice carrying throughout the chamber, "your constitutional argument contradicts at least 3 major precedents that have stood for decades. Perhaps you should familiarize yourself with Harrington versus Davis before presenting such theories to this court." The sudden shift in Barrett's tone left the courtroom in stunned silence. The questioning had taken a sharp turn, and those present knew this would not be just another routine argument. Barrett had always been known for her incisive questioning, but this felt different. An intellectual gauntlet had been thrown. Bondi stood frozen at the podium for a brief moment, her mind racing. She had expected tough questions. This was the Supreme Court, after all, but this direct challenge was unexpected. The weight of the moment settled heavily on her shoulders. Would she buckle under the pressure, as some had predicted, or would she rise to the occasion? Without missing a beat, Bondi straightened up, her voice steady as she began to speak. "Justice Barrett, I appreciate your question. And while I am familiar with Harrington, I would like to explain why it actually supports, rather than undermines, the position we are presenting today." Barrett's expression shifted imperceptibly, her eyebrows rising slightly in skepticism. She had expected Bondi to flounder, but what she didn't expect was the depth of legal analysis that was about to follow. "Please go ahead," Barrett said, her tone cool but inviting. Bondi took a deep breath, and with a calmness that belied the high-pressure environment, she launched into her argument. Harrington's central holding, Justice Barrett, revolves around the interpretation of the Commerce Clause, which Chief Justice Reynolds limited to circumstances where federal regulatory interests outweigh state sovereignty concerns. What is often overlooked in Harrington is Justice Kavanaugh's concurrence, which established a 3-part test for evaluating whether federal regulations infringe upon state authority. The courtroom fell into a deep silence as Bondi's words echoed throughout the chamber. Barrett's posture remained stoic, but there was a noticeable shift in her demeanor. She had been expecting a simplistic defense of Bondi's position, but instead, she was receiving a meticulously crafted counterargument. "Now, applying this test to the current case," Bondi continued, "we see a critical distinction. The federal regulations at issue here do not meet all 3 prongs of Justice Kavanaugh's test, particularly the 3rd requirement, that federal action must be tailored to minimize unnecessary state administrative burdens." As Bondi spoke, her confidence grew, and the justices around her began to pay closer attention. Barrett's cool, analytical gaze remained fixed on Bondi, but there was no denying that the tone of the exchange had shifted from adversarial to intellectual curiosity. Bondi's next move was a deft one, she smoothly transitioned to a lesser-known case that had been pivotal in shaping federalism jurisprudence. This limitation was further clarified in Westmoreland v. United States, a 10th Circuit decision where the court invalidated federal regulations that failed to meet the tailoring requirement, despite acknowledging the legitimate federal interest at play. Justice Sotomayor, ever the sharp questioner, leaned forward, her voice tinged with disbelief. Westmoreland? That's not a Supreme Court precedent. How do you reconcile that with the weight of binding authority? Without a hint of hesitation, Bondi responded, Yes, Justice Sotomayor, Westmoreland is a 10th Circuit decision, but it was cited approvingly by this court in Montgomery v. Louisiana, specifically in footnote 23, when discussing the limits of federal regulatory power. While it's not a Supreme Court ruling, its reasoning directly informs the issue we face today. Barrett, who had initially sought to undermine Bondi's position, now appeared more interested in the details of the argument. She leaned slightly forward, a silent acknowledgement of Bondi's legal expertise. You've clearly done your homework, Miss Bondi, Barrett said, her tone softer, though still inquisitive. But I have concerns about your interpretation of Article 3 jurisdiction. Bondi nodded respectfully, anticipating the question. I understand the concern, Justice Barrett, but I would direct the court's attention to Justice Scalia's dissent in Williamson County, which addressed the jurisdictional limits of federal intervention in state matters. While his dissent didn't ultimately prevail, the reasoning was later adopted in Nick v. Township of Scott, which, as you know, overruled the majority position in Williamson County. Barrett's expression shifted again, this time to one of curiosity. Are you suggesting that Nick's reasoning regarding property rights extends to the broader federalism concerns we're addressing today? Bondi's response was calculated, confident, and precise. Yes, Justice Barrett, but not through a simple analogy. The reasoning in Nick has been extended in a series of lower court decisions, gradually expanding its application to broader federalism contexts, well beyond property rights. The interaction between Barrett and Bondi had evolved. What had started as a sharp confrontation had now morphed into an intellectual exchange between two formidable legal minds. Barrett, ever the scholar, was visibly engaged, her previously skeptical stance now replaced by genuine interest. The justices, who had been passive observers moments earlier, now leaned forward, eager to hear more. Justices Thomas and Kagan both offered questions, and Bondi responded with an impressive level of detail, addressing each query with precision and clarity. Every time she spoke, the case grew more complex, more nuanced, and more difficult to dismiss. When Justice Alito raised a potential conflict with the court's recent ruling in Texas v. Johnson, Bondi expertly distinguished the cases on grounds so specific that even the most seasoned justices were seen flipping through their casebooks, confirming her assertions. Barrett, now fully aware of the intellectual rigor that Bondi was displaying, returned to the issue of Dennison, a framework for evaluating federal-state conflicts that had been pivotal in earlier decisions. Your interpretation of Dennison, Barrett began, her voice steady but probing, would require us to narrow its application significantly. I'm concerned about the broader implications of such a shift. Bondi didn't flinch. Justice Barrett, I have tremendous respect for Dennison, she began thoughtfully. However, applying it to our case requires us to acknowledge its inherent limitations. Justice Gorsuch himself recognized these limitations when writing for the majority in Dennison. The framework was never intended to provide blanket protection for all federal regulations. It's designed for typical assertions of federal authority, but there are cases like ours where a more nuanced analysis is necessary. Bondi continued, building her argument with intellectual rigor. In fact, the situation we face today represents exactly the kind of exceptional case that Justice Gorsuch anticipated. The federal regulations at issue technically comply with Dennison's formal requirements, but they functionally eliminate state discretion in a manner that the framework was never designed to allow. The tension in the room was palpable as the clock ticked down on Bondi's time. Yet, instead of rushing to summarize, she took a moment to refine her points with a clarity that left no room for doubt. Her command of the case law, her understanding of federalism principles, and her ability to synthesize complex legal theories had become undeniable. As the Chief Justice announced that Bondi's time had expired, an unusual thing happened. Justice Barrett, who had originally sought to challenge Bondi's arguments, requested additional time for Bondi to complete her analysis. It was a rare and telling moment in Supreme Court history, one that signaled not just respect but recognition of a formidable advocate in the courtroom. The effect of Bondi's performance was immediate. Legal blogs, constitutional law forums, and academic circles erupted in discussion. Bondi's argument had not only silenced her critics, it had reshaped the debate around federalism in a way that few could have anticipated. When the court's opinion was eventually issued, it was a clear victory for the states, with a 6-3 decision that incorporated significant portions of Bondi's framework for analyzing federalism conflicts. Even more remarkably, Justice Barrett wrote a concurring opinion that directly engaged with Bondi's arguments, acknowledging the persuasive application of her legal reasoning. The media frenzy surrounding the case was intense. Headlines blared. Barrett meets her match in Bondi, a legal masterclass in the Supreme Court, and Bondi's brilliance reshapes federalism debate. Legal scholars and pundits from across the ideological spectrum praised her intellectual rigor and legal acumen, with many recognizing the profound impact she had on the court's thinking. For Bondi, the experience marked a turning point in her career. She had faced down one of the nation's most respected justices and emerged victorious. The legal community, which had once doubted her, now saw her as a force to be reckoned with. Law firms began seeking her expertise, and academic institutions extended invitations for her to speak on the evolution of federalism jurisprudence. As months passed, Bondi and Barrett shared the stage at a Federalist Society event where their mutual respect was evident. Barrett, reflecting on their courtroom encounter, remarked, "True intellectual growth comes from being challenged by arguments that force us to reconsider our assumptions." Bondi responded, "The strength of our legal system is built on rigorous debate and the willingness to engage with ideas, no matter their source." The lasting legacy of that day in the Supreme Court chamber was clear. It was a powerful reminder that, in law as in life, the most profound breakthroughs come not from defending the status quo, but from questioning it and embracing new perspectives. And for Bondi, it was a testament to the power of intellect, preparation, and the willingness to rise to any challenge.